Welcome back. This is part 3. So what about our case? Does the CISG apply? Well, let's have a look at the requirements of Article 1, namely an international sales contract and one of two specified relationships to the CISG. First of all, we need a sales contract. The sales contract on movable goods that is concluded between parties with places of business in different states. In our case, obviously, we do have this. We have a sales contract on a machine, a movable good, between XSA and Y Limited, and those are based in different countries. It's not a consumer contract that would have been excluded from the sphere of application according to Article 2 of the CISG. It's not a sale of goods bought for personal, family or household use. It's rather a sale that belongs to a business context. And looking at Article 3, even if we assume that at the time the contract was concluded, the machine had still to be manufactured by XSA, this doesn't change anything about the fact that we have a sales contract within the meaning of the CISG, since the supply of a good of that machine was obviously the preponderant part of the obligations of the seller, XSA. So the first requirement, an international sales contract, is met in our case, which leads us to the second requirement, the alternative condition specified in Article 1, paragraph 1a and b. There must be one of two specified relationships to the CISG. The first alternative is that both states involved are parties to the CISG. However, in the present case, this condition isn't met. While Switzerland has ratified the convention, India is not a party to the CISG. This brings us to the second alternative. The CISG can also apply if the rules of private international law lead to the application of the law of the contracting state. What about our case in that respect? If we assume that a court in Yverdon, Switzerland, deals with the case, that means that Switzerland is the forum state, and the court in Yverdon would refer to the Swiss private international law rules for determining the applicable law, which means that we have to go into the Swiss Code of Private International Law. And we did that, as you might remember. We had a look at the specific part of the code, namely Chapter 9, Section 1 on contracts. And we mainly referred to Article 117, according to which the contract shall be governed by the law of the state with which it is most closely connected. It being presumed that the closest connection exists with the state in which the party who must perform the characteristic obligation is habitually resident or has its place of business. Well, in our case, obviously, XSA is the party that has to perform the characteristic obligation by delivering that machine, whereas Y Limited has just to pay an amount of money, which leads us to the conclusion that Swiss law is the applicable law according to the Swiss Code of Private International Law. But what exactly is the relevant Swiss law? Is it the Swiss Code of Obligations, or could it be the CISG instead? Well, as we have seen, Switzerland is a CISG member state. And as we have seen also, the CISG is a self-executing treaty. And that means that the CISG is directly applicable. It becomes part of Swiss law. It becomes the relevant Swiss law for international sales contracts, so to speak. So as you can see, we are exactly in this situation. The rules of private international law lead to the application of the law of a contracting state, which leads us to the conclusion that the CISG applies to our case as the relevant Swiss law. The relevant Swiss law is not the Swiss Code of Obligations in our case, but the CISG. However, this is not a mandatory consequence. Article 6 provides for an opting out option. According to Article 6, the parties may exclude the application of this convention or derogate from or vary the effect of any of its provisions. The CISG is based on the principle of party autonomy, which means that the parties remain free to derogate from its provisions or to exclude its application altogether. But we have to be careful here. Such an exclusion of the application of the CISG has to be done in a clear way. Warning: a simple choice of law clause is not sufficient. Consider this example. The present contract shall be governed by Swiss law. What exactly is the consequence of such a clause? Well, according to the Swiss Code of Private International Law, Article 116, that clause is to be taken into account by a court. The contract shall be governed by the law chosen by the parties. And since the parties have chosen Swiss law, it's Swiss law that shall apply. But what exactly is the relevant Swiss law? And this brings us back here. If the rules of private international law lead to the application of Swiss law, it's the CISG that applies as the relevant Swiss law and not the Swiss Code of Obligations. So if the parties want to opt out of the CISG, if the parties want to exclude the application of the CISG, they have to do so expressis verbis in their contract. Otherwise, the CISG may apply according to Article 1, paragraph 1b. Here you have an example of how the CISG can properly be excluded. The present contract shall be governed by Swiss law at the exclusion of the CISG. This, of course, leads to the further question of what is better in a specific case. And let's think of our case involving XSA and Y Limited. What is better? Is it better to have the CISG applying to that contract or to exclude its application in favor of the Swiss Code of Obligations? We are going into that question in a moment by comparing the CISG to the Swiss Code of Obligations. But before we do that, let's have a look at the structure of the CISG. The CISG contains 101 articles that are divided up in 4 parts. The first part features Chapter 1 on the sphere of application, Articles 1 to 6, and we know these articles already, and Chapter 2 containing some general provisions. Part 2 focuses on the formation of the contract, which is what originally was covered in the ULF. Part 3, which is the main part, regulates the rights and obligations of the seller and the buyer. It is divided up into 5 chapters: general provisions, obligations of the seller, obligations of the buyer, passing of risk, and provisions common to the obligations of the seller and of the buyer. Part 4 adds some final provisions. And here you have the overall picture. In the next step, I would like to turn to the comparison between the CISG and the Swiss Code of Obligations. In this comparison, we won't be able to cover everything. Rather, we will focus on some of the more important issues in practice. So, what is similar and what is different? And what is better? Let's first have a look at how the CISG regulates the issue of the passing of risk in Part 3, Chapter 4. Article 66 offers a definition of the passing of risk. It states that Loss or damage to the goods after the risk has passed to the buyer does not discharge him from his obligation to pay the price, unless the loss or damage is due to an act or omission of the seller. So it's all about the risk of the buyer being obliged to pay the fixed price to the seller without receiving the goods he bought or while receiving them in a damaged condition. In a typical sales transaction, there are several stages. At some point, negotiations are started. Later, a contract is concluded. Then the seller prepares the goods for shipping. Then the seller sends the goods on their way to the buyer. And finally, the buyer receives the goods. So at which point does the risk pass from the seller to the buyer? According to the CISG Article 69, that contains the default rule referring to the passing of risk. According to this provision, the risk passes to the buyer when he takes over the goods. On our blackboard, this corresponds to this point in time when the goods are delivered to the buyer. But what about the Swiss Code of Obligations? I invite you to compare Article 69 of the CISG to Article 185 of the Swiss Code of Obligations. Are the solutions provided for in those two articles similar or different? Try to place the solution of the Swiss Code of Obligations on this timeline on the blackboard.